Good afternoon, everyone. This is Patrick DeRay, Chief of the Bureau of Automotive Repair, and I want to welcome everyone to our regulatory workshop talking about a subject that we first workshopped back in April, and we've come a long way since then with some changes and amendments to the draft regulations that we wanted to share with all of you based on all the excellent feedback we got at that April workshop. This is now officially our second public workshop to discuss the proposed regulation. It's an extension of our citation program that we're discussing here to take on Automotive Repair Act violations by registered automotive repair dealers. The first workshop that we held had a lot of language that we came close on, but we missed the mark in a couple of areas, and I think we wanted to get some additional feedback based on the changes we made that were responsive to your initial comments. As many of you know, the regulations currently that we have to issue citations are limited strictly to smog check program violations under the Health and Safety Code, and then unregistered or unlicensed activity. Those are auto repair shops that are performing as an automotive repair dealer but not registered with the Bureau of Automotive Repair. We will issue a citation with usually just an order of abatement, realizing that the cost of complying with a citation for unregistered activity is the $200 registration fee. So there usually isn't a penalty associated with such a citation for unregistered or unlicensed activity. So those are the two areas that we issue citations for right now. And this package looks to expand it to Automotive Repair Act violations, a limited number of violations under the Act. We're not proposing to go crazy with all of the potential areas and sections of the Automotive Repair Act that could potentially could be identified for citations. So we have with us today the person who's been working on this package. A couple of individuals in particular have led an internal work group. Greg Pearson. Greg, let's see, I want to make sure you're here. Oops. Not sure if Greg's here. Greg Pearson, though, chaired an internal work group and worked also very closely with Matthew Gibson. Both of those individuals work in our enforcement operations branch and kind of spearheaded an internal effort to develop this regulation package. And Matt, I believe, is going to be presenting to us today the latest draft of those proposed regulation changes. Matt, are you here with us?
I am here with you.
And are there any, is Greg here as well, or did I miss his name?
I know he has left the office, but he indicated he might get logged in when he gets back home. But
okay, so you're going to take it from here. All right. Did I miss anything, or is there anything you want to fill in or add before we get started?
No, only would say that, we originally presented on our rationale for wanting to do an automotive repair dealer citation program in the October 2020 bag. Obviously, in April, we had our first workshop on the proposed text, and this is our second, as you already said, this is our second workshop on the text. Assembly Bill 471 would make significant changes to a portion of the proposed text if it becomes law, specifically related to a informal citation process and a panel, some of the stuff that we covered during bag. So I won't go in depth on that at the moment, but I will point out when we get to that section which section it is. And obviously, based on the feedback we got from the last workshop and internal discussions and discussions with DCA Legal, this is our revised regulatory language. So I have it in a PowerPoint so everybody can follow along. And Sarah, do I have control of this or no?
Yeah, I think you do.
Yes, you have control of the PowerPoint.
Okay.
Let me just mention real quickly also that we have a number of our bar advisory group members who joined us for the workshop. So they've been promoted to panelists and are there on the virtual dais, if you will. And then we have a number of public members, some of whom are bar staff, as well as industry and other representatives, it looks like. So we'll be calling bar advisory group members and public members for questions and comments, but we'll wait till the end of the presentation for Matt before we do that. And one last thing, this is being webcast, and we'll hope to have a recording of the webcast up on our website and publicly available to everyone sometime next week. So without further ado, we'll turn it over to Matt Gibson for the presentation. Thank you, Matt.
Thank you, Pat. And again, I'm Matthew Gibson. I'm a program manager in the Enforcement Operations Branch. And this is our presentation on the Automotive Repair Dealer Citation Program. So the purpose of the regulations would give BAR the ability to create an automotive repair dealer citation program that is consistent with existing citation programs for smog check licensees and unlicensed activity, address violations of the Automotive Repair Act that do not rise to the level of an administrative action through the issuance of a citation. It would define negligence in automotive repair and make other minor clarifying changes. So there would be a new article 11.1, administrative citations and fines for Automotive Repair Act violations. And that would consist of a new California Code of Regulations 3394.50, authority to issue citations, fines, and orders of abatement to automotive repair dealers. The bureau chief or his or her designee is authorized to determine when and against whom a citation will be issued and to issue citations containing orders of abatement and fines for a violation of licensees of Chapter 20.3 of Division 3 of the California Automotive Repair Act or any regulation adopted by the Bureau. 339450B, each citation shall be in writing and shall describe with particularity the nature and facts of the violation, including a reference to the statute or regulations alleged to have been violated. The citation shall be served upon the individual personally or by certified mail. There would be a new California Code of Regulations 3394.51, administrative fine amounts, orders of abatement, and citable offenses for licensed auto repair dealer violations. The chief or his or her designee may issue a citation containing an order of abatement without issuing a fine for the first violation of any provision set forth below in subsection B. A citation may include a fine from $100 to $5,000. In assessing a fine or an order of abatement, the Bureau shall consider the following: the gravity of the violation, the good faith of the licensee, violation history, and factors in aggravation and in mitigation of the guidelines for disciplinary orders and terms of probation as referenced in section 3395.4. Let's see, what section am I on? We'll go with subsection B. The chief and his or her designee may issue a citation for violation of any of the following provisions. And I'll say that this is not obviously the way that it's listed out in the proposed text. I grouped the sections by type so that they would be easier to follow. So trade standards violations sections, we'd be having ball joints, automatic transmissions, engine repairs, ignition interlock devices, vehicle identification information, auto body and frame repairs, automotive windshields, automotive air conditioning, inflatable restraint systems or airbags, and commissions, considerations, inducements, or referral fees for towing services. There'd also be issues for violations for equipment requirements for auto body repair shops and for auto conditioning repair dealers. There would be a new California Code of Regulations 3351.7 for negligence. There would be a new California Code of Regulations 3356.1 for inaccurate invoices, and also for maintenance of records. Subsection C, a citation that lists multiple violations shall not exceed $5,000 as specified by Business and Professions Code Section 125.9. A citation issued under this section shall be separate from and in addition to any other administrative, civil, or criminal remedies. There would be a new section, new California Code of Regulations, section 3394.53. Contested citations and requests for formal citation hearing for automotive repair dealers. And this is the section that would be most impacted by the passage of Assembly Bill 471. If a person cited wishes to contest the citation, that person shall, within 30 days after service of the citation, file in writing a request for an administrative hearing to the Bureau as specified by Business and Professions Code Section 125.9. If a hearing is not requested pursuant to this section, payment of any fine shall not constitute an admission of the violation charged. Hearings shall be held pursuant to Chapter 5 of Part 1 of Division 3 of Title 2 of the Government Code. This is the new California Code of Regulations 3356.1, Inaccurate Invoices. An automotive repair dealer shall not create an invoice that is inaccurate in the recording of service and repair work performed and/or parts supplied. This is the new California Code of Regulations 3351.7 for negligence. An automotive repair dealer shall not commit negligence in the maintenance of and/or repairs to a motor vehicle. Negligence means a deviation from an ordinary standard of care that could foreseeably result in injury or harm to a consumer, personal property, or the public during or as a result of repairing a motor vehicle. I will say, for some reason, the "of" is not in my PowerPoint presentation, but it is in the regulation text. And the last one has to do with a change we made to California Code of Regulations 3358 for maintenance of records. The actual addition, because of remediation, got shifted down to the next slide. So, pursuant to Section 984.11 of the Business and Professions Code, each automotive repair dealer shall maintain in either written or electronic form legible copies of the following records for at least 3 years. Skipping down to subsection D, all such records shall be open for reasonable inspection and/or reproduction by the Bureau or other law enforcement officials during normal business hours. And the new D1 would say, failure to maintain and make such records open for reasonable inspection and/or reproduction when requested by the Bureau as part of a consumer complaint investigation may be grounds for disciplinary action or issuance of a citation. And I think that was the end of, yep, it's the end of the PowerPoint.
All right. Thank you, Matt. As you can see, there were some significant changes made as a result of the comments we received at the April workshop. And now want to open it up again for public. Well, let's start with advisory group. Although this isn't an advisory group member meeting, we'll certainly defer to advisory group members, and then we'll open it up additionally for public comment from non-advisory group members. Let's start with the first name I saw, Johan Gallo. No sound is coming through, Johan. Still no sound on our end.
Guess it helps if I push the right button. Anyway, I appreciate the presentation, Matthew. We've been looking at the revised regulations and appreciate the work that's being done on this. We do have some concerns as it relates to, just as an example, inaccurate invoices. And the reason that's of concern is I've not only worked with the retail division of Bridgestone Firestone, but also in my afterlife, working with the California car dealers through AAS and doing various audits on automotive repair shops. One of the big issues that many repair shops deal with is the job descriptions that are really born in the software from the manufacturers, whether it's the car manufacturers, the manufacturers of the system that the shop is running as far as shopware. And so the concern that we have is when we look at inaccurate invoices, while it's not the intent of the shop to inaccurately report the work that was done, sometimes it's born out of the software design, and lines get truncated, abbreviations get put in when they should have been spelled out. And so we have a concern as it relates to inaccurate invoices when, especially when I was dealing with the car manufacturers, because their attitude was basically, we're not changing our system for California. All the other states are fine with our software. So that was one of the concerns that we had. As far as gross negligence, I think we still need to do some work on better defining gross negligence.
Well, we don't have gross negligence anymore.
Excuse me, let me drop the word gross. I appreciate that change. Again, I'm living in past language, so I apologize. But as we're dealing with negligence, I understand the intent of what we have on item B on your slide 10. And I think it's one of those, while we're dealing with negligence, was it intent or was it an error or accident? So those are just a few of the things, and I know others have issues that and the items they want to comment on, so I don't want to take too much time, but just to kind of start things going, those were two of the key things that I and a lot of the members of Cal ABC were having heartburn over. So with that, I'll turn it back over to you guys.
Well, I was just going to ask a follow-up question related to
Sure.
inaccurate invoices, just that you raised an issue about the concern related to software that you believe would create an invoice that was inaccurate, or it could be misleading. I'm thinking in the situation of a consumer complaint where if it actually recorded something that wasn't true, I know how the violation would be reflected in the consumer complaint investigation. I guess what my question is that is there something about the wording in this proposed regulation that you would want to change, or are you saying it shouldn't exist at all?
Let me give you a couple of examples that might help, Matthew. As we're working with some of these software packages, they come pre-populated with language that for California is not acceptable because it's not total disclosure. One of those is the word reman. We know it means remanufactured, but you have to spell it out in California to where other states reman would be acceptable. R&R is another one, remove and replace. And those are just two simple examples of some of the issues that we're running in with car dealers, as well as other retail businesses that we did audits on, where in some cases, these jobs are what we call truncated. In other words, they're shortened because each line is limited to X amount of characters because of the way the software is designed. And so in those two examples, if we are to look at recording the work as performed as the parts and services supplied, those would not meet the guidelines under California regulations for total disclosure.
Okay, let me ask you then about negligence real quick.
Okay.
Is there something about the definition that you believe needs to be changed? You said we need to work on the language. I guess I'm wondering what you're saying about the definition that you're finding a problem with. And I ask because when we went through this back in April, when it said gross negligence, everybody said it really looked like negligence. So I guess I'm just trying to understand what you.
No, and I appreciate that too. I'll give you two examples there. When you're doing repairs on a vehicle and the vehicle leaves and you have a technician that failed to tighten the lug nuts and you have a wheel off, I mean, that's a fireable offense for most businesses, okay? And that is negligence. But was it intent? No different than somebody does an oil change, and when they're doing the oil change, the gasket is left in place from the old filter and the new one gets put on, and you have negligence because now you've got a situation where you've created an oil leak and in most cases an oil out. Neither of those are acceptable in our business, and I think everybody on this call that's in this business would agree. But when we're going through that, was it intent or was it an accident? And that's really the area, a couple of the areas that I struggle with.
Okay, thank you.
All right, let's see who else is here. Let's go with Anthony Bento with the California New Car Dealers Association. Anthony?
Thank you for the opportunity to speak, and I second what was just said, but I also have a couple of additional comments regarding the first, the reasonable inspection of records. I was wondering if there's any, if to the extent you've thought about what that would be, what reasonable inspection would mean. The Department of Motor Vehicles, for example, has a 3-day period where they basically say that you need to produce records within 3 days of request. Reasonableness is obviously a much more nebulous standard. It could be in the dealer's, the ARD's advantage in some circumstances. It could be in their disadvantage in some circumstances. Wondering what your thoughts are on that, and what whether you would consider some more definitive standard.
So we haven't taken a position about what actual reasonable is as far as like officially. Internally, we might have our own opinions, and they might actually vary from field office to field office as far as what they think a reasonable time frame is for the production of records. I would say that if I relate this back to the time I was in the field, right? I would normally, if there wasn't a reason to not call the shop in advance of going to the shop, I would normally call the shop and I would tell them that I was coming to talk about a specific consumer complaint. And I'd ask them to get the records or make copies of the records so I could get them while I was there so we could deal with it all at one time. And if they provided them, it was reasonable for them to do so, and it all worked out. If I went into a shop and I asked for records and they said they couldn't get them to me for 30 days on a single consumer complaint on one transaction, that might not be reasonable. And I think telling a shop owner, we could work it out to finding what would be acceptable for both of us, assuming the shop is reasonable. But so given that what's reasonable for one shop might be not reasonable for another, and the transactions themselves could be more complicated from one type of repair to the other, we have tried to not say what reasonable is, or haven't really taken a position on what reasonable is. I don't think it's a bad idea. I mean, if we could define a regulation, I mean, what do you have any thoughts?
Well, if you set a 3-day minimum advance notice and then add language that kind of captures the concept that the volume of the request should be weighed against the amount of time that the ARD has to produce the document. So obviously, if the request regards one specific consumer in a singular incident, then 3 days could be totally appropriate in that circumstance. But if the request was totally voluminous and included, theoretically, you could ask for all 3 years of documents. I would suspect never do that, but like it's a theoretical possibility to just ask for all of those, all of the ROs or invoices for that entire period. In that situation, given the volume of it, the documents requested, it may be more appropriate to provide much longer time frame to produce those documents. So maybe like a 3-day minimum coupled with the concept that the additional time may be warranted given the volume of a request. That might be one way to approach this issue and defining what reasonableness means with respect to this proposed regulation.
Okay, I'll say one thing. If you're looking at D1 or the new D1 that doesn't exist yet, it's meant to limit the scope of this violation to the request of transactions documents related to a consumer complaint, as opposed to somebody making a broader request as part of an investigation. So for example, if we'd asked for 3 years, so I should say, we have the authority to ask for 3 years worth of records. It just exists. And if we wanted to get those records because we felt we could, through looking at those records, determine there was some sort of fraudulent conduct or predatory business practice, if a shop failed to provide those records, we would probably end up dealing with it more through the administrative process versus a citation. because they're not directly related to a complaint. This is more having to do with getting records related to a consumer complaint. One other thing I was going to say was that I don't know that I want to set a minimum. Like I have to ask 3 days in advance or make a written request 3 days in advance before they would have to produce them. I would almost think about on the other end of it as far as a maximum, because given the scenario I just laid out about I used to call shops, hey, I'm going to be there tomorrow. Can you get the records together? Given what you just said, I wouldn't be able to go out there for 3 days. So I don't know if, I mean, there's some flexibility we want to have, and I'm trying to figure out the best way to accommodate that. But the idea of setting some sort of a time frame, it's not a bad idea. I guess we probably could discuss it as a group and come up with something.
Yeah, and the concern that I have on this specific one is that if someone just shows up, the ARD is really busy with managing different, like they have a lot that they're juggling, and an inspectors just demands a bunch of documents, and there must be a better way to approach it and approach a situation than that. And calling a day in advance may be appropriate in some circumstances. Again, I reference the 3-day period because it's in existing regulations adopted by the Department of Motor Vehicles, something to consider. But I think that that we just want to again avoid the situation where the ARD feels like they're not able to add it. No one wins in a situation where the ARD is not adequately able to respond to a request because someone just shows up at an office and starts demanding records, and it's a particularly difficult time to respond to a request like that. So, yeah,
I can agree with that.
The other comment that I have regards the individual service of the I think it's the proposed subdivision B in 3394.50. So what exactly would an individual service, what would that constitute in the corporate context? Like if you're thinking about a complaint, there's like a designated individual that receives service of process. You can't just, if you're suing Target, you can't just show up and hand a complaint to any employee at Target saying that we're suing you. There's a designated agent for service of process. What in this context, what does personal service mean to an individual when the ARD is a corporation?
All right, so perhaps individual is the wrong word, and so maybe a good thing you brought it up. So the citation shall be served upon the individual personally or certified mail. Individual in this context would be a licensee or a registrant. But since you're bringing it up, if we think about how we deal with small check citations, we don't personally serve them anymore. Everything goes through the mail. And so if I like the flexibility that this allows BAR in the future to decide how to deal with it, because theoretically, if you look at the list of violations, some of them maybe could be served in the field. We issue the citations for unlicensed activity, the unregistered ones. Those ones are done in the field on the first level. So let's just say, for example, we're in a situation where, I don't know, somebody doesn't produce records within 2 weeks, or something that was unreasonable. Maybe that was a citation that could be issued in the field, but other ones might have to come through headquarters. There's some flexibility that this allows, but honestly, if we're going to try to be consistent, maybe we should just drop the individual personally, like from that line. But I don't know. I guess we should. So there's two different options.
I see less of a problem with their service through certified mail than individual personally, without it being further clarified as to what that means. Because again, I think if we're talking about a citation, it should be served upon someone who has the authority to receive that on behalf of the ARD. My understanding that the application for an ARD license requires individuals to be listed as owners, or that persons with management or the employee the oversight responsibilities. So perhaps limiting it to that, if you want to keep that flexibility, limiting it to only those individuals listed, or to constrain it in some way. So the idea is just that that an employee individual service cannot be effectuated by just handing it to any employee at the ARD. And then if that employee, for whatever reason, doesn't because they just don't know what to do with it, doesn't handle it properly, then they default on their ability to challenge it. And it's just that they feel like that they're not, that the ARD is in a situation where they were not adequately served. So again, I think that either striking it or providing more clarity about what exactly that means would be really helpful.
Good point.
All right, let's go to our next. Thank you very much, Anthony. Let's go to
you.
our next commenter. Looks like Nikki Ayers is next on my list, representing the Independent Automotive Professionals Association, IAPA.
I'm sorry
Welcome.
I wasn't there this morning. I had a conflict. I apologize.
No worries.
I'm not going to ask the same question that was answered this morning. Is there any provision in this to figure out a way to have $0 rather than $100 as the minimum fine?
Yes. I gotta find it though.
That's already been answered. Okay.
Well, so
And then-
do you want me to? I was just going to point out it's right here in the section of the A. So it does say a citation may include a fine amount from 100 to 5,000, but the chief or his or his or her designee may issue a citation containing an order of abatement without issuing a fine for the first violation of any of the provisions set forth below. So I know I came up in the first bag, and so that's how we addressed it.
Okay. And then the list of the things of standards, engine changes, I don't recall that that's something that's addressed. Is that just a placeholder?
No, that's the California Code of Regulations 3362.1 is engine changes.
Oh, engine changes? Okay.
Mhm.
I didn't remember
Yeah, I'll just,
being it that way. I'm sorry.
No, that's okay. This is all, this is everything in Article 8 of, in the
Okay.
California
I
Code of
don't-
Regulations
just
that
didn't
are
remember the
trade standards.
chapter of that section being listed that way. Okay.
It's probably not something you see very often. That's probably the reason why.
It's getting to be more more use. That's all I wanted. Thank you.
All right, thank you, Nikki.
Okay.
Let's go next to Dave Kutha with the Automotive Service Councils of California, ASCCA. Thank you, David, for attending.
Thank you, Patrick. Glad to be here. Thank you, Matthew. So just building out a little bit on the paperwork end of this. So I like to look at things, take it to the extreme, and what does the extreme look like? So, or a min-max kind of thing. So if it was a consumer complaint that we needed paperwork, from 3 days ago, at my shop, I could come up with that paperwork in, minutes to hours, right? If it's a situation where, we'll go with an engine change and, that's still under warranty and there's a warranty issue and it happened, 2.5 years ago, and you wanted to see, the original paperwork and invoices and sublet invoices and things like that, that would take days to track down, right? Because that stuff's going to be up in a box up in the attic someplace, probably mislabeled because I can't read my own writing and those kinds of things. So I think an easy solution would be to put a number on there, because again, right, one person's reasonable and another person's reasonable aren't necessarily the same. So, if it was like an up to 10 business days kind of number, I think that would be reasonable. I think anybody, that is able to get out of bed and run a business on a day-to-day basis should be able to put their hands on records within 10 business days in any given situation.
So like, okay. That's fair. So like within 10 business days, they should be able to produce them within 10 business days. So what you're suggesting, I want to make sure I understand, is that this would have to be reworked, but basically it would say something along the lines that those records related to a consumer complaint investigation shall be provided within 10 business days. And that we issue a citation if you can't meet that standard. Is that what you're saying?
I think that would, in my opinion, that would be fair and reasonable. Yeah. And Nikki asked my other question about the $100 deal, so thank you. That's all I had.
Okay, well, thank you.
I don't know how common it is that we get consumer complaints that date to transactions that occurred years ago. Usually there's a current repair transaction or one that was recently completed that we would be following up in response to. And we have a goal. What's our goal, Matt? 45 days to close out a complaint. So that's some of the reason behind the interest on the part of BAR to close out to get the records timely so that we can meet our goals of closing out these complaints and investigating and responding to them as expeditiously as possible. I don't know what a reasonable amount of time is, but again, I don't think we wouldn't be asking for a single consumer complaint record for a transaction that occurred years ago. That would usually be part of a larger investigation that wouldn't be the subject of this type of inquiry or request.
I'm just thinking, Pat, of something that would relate to perhaps a warranty issue, right? And many shops now are 2, 3, 4-year warranties, and so if it's 2.5 years from now that we replaced an engine, and
Hadn't thought about that situation.
Yeah.
That's a good scenario. Yeah.
Yeah, and like restoration complaints are the worst.
Restoration.
Yeah, exactly. Right. Yeah.
But yeah, our
5-year repairs I've seen in some cases,
Yeah.
and they go on for many years.
Yeah.
But I would say our authority ends at 3 years, so it would be within a 3-year time window that we're looking back on. But okay.
Thank you. Let's go next to Jack Maladonov with the California Auto Body Association and other associations. Jack?
Thank you, Matt. Yeah, no, I'm on. Thank you very much. Appreciate it, Matt, for the presentation. Also want to acknowledge the changes that the BR has made since the last BR workshop. I know there have been some substantive changes. I know you eliminated the citation for false and misleading advertising, which was very controversial. You also eliminated the citation for generating false and misleading invoices, and also eliminated the issue of gross negligence. So that's much appreciated. I do have some comments and some suggestions, and if you can indulge me here, I'd like to go through your presentation and just numerically in terms of the pages. Page 4, and I know Anthony touched on it, and I don't want to beat it to death, but yeah, that the issue there, the way it reads right now, that the BAR can issue a citation and simply drop it off at the facility, and it could be dropped off with I think you consider it a responsible managing employee or anyone there. And unfortunately, you have absentee owners, you have chain stores, and you may have someone there that buries it or loses it. So I think it's important to really look at that sentence and that section to make sure that the principal or the owner of the facility gets notice of the citation. So I think Anthony covered that very well. Page 5. I know Dave and also Nikki talked about that $100. I got to tell you, I've looked at the statute, and I know you're familiar with it too. But in the Business and Professions Code 125.9C specifically allows the BAR to issue a citation without any assessment. And I know one of the suggestions was to put it to zero. 0 to 5,000. You do have authority in the statute. It's capped at 5,000. I'm not really sure how that $100 came up. I know it's in the smog check regulation, but it's nowhere in statute. And I don't think there's any basis for it in statute. I think in my opinion, I think it's the statute provides 0 to 5,000, and I would suggest that's changed to 0 to 5,000. It'll give the opportunity to the BR representative. At that point, let's face it, there may be a situation where the BR representative may say, hey, do I really issue a citation for $100, or should it be 0, or do I even issue the citation here? It could be a situation where they say, hey, maybe this is an educational conference of some sort. So I do think it's significant. I know some people say, hey, what's the big deal about $100? I do think it has ramifications. So my suggestion would be to follow the statute and put it at 0, Matt, 0 to 5,000.
Okay. You're right about 125.9. You're right. It's not like $100 minimum within there, within that code. I was going to say though, you're also right about our smart check citation, in which there is a $100 minimum. I think we're here with this. When you guys raised the issue in the last workshop, we dealt with it in the way that we ended up dealing with it, as far as how we talked about an order of abatement without a fine and the first violation. There's other programs within DCA. I don't that started $100 minimum too, and so I'm thinking that's probably, we're trying to be consistent and maintain consistency. So that was probably the reason why we've hung on to it the way we have.
Yeah, I just don't see it anywhere in the statute. I think it just came up, you know, someone, at one point it came up and $100 was kind of a nice round number, but it's nowhere in statute. It's in the reg, but again, just because it's in the reg, I know you want to be consistent. I'd be more consistent with the statute, but those are, you know, that's my comment on that.
Okay.
The next is page 6. So let me, on the trade standards, and let me zero in on 3365, auto body and frame repairs. And this one's important for the auto body industry because this section is really the section that deals with the trade standards. And the auto repair dealers and body shops follow, when they repair a vehicle, the section indicates that you have to follow, the repair shall be performed in accordance with OEM specifications or nationally recognized and, you know, nationally distributed and generally recognized by the auto body industry. And so this one's a little bit, I guess, gray. And so let me just give you a scenario from the auto body perspective. If the manufacturer, the original equipment manufacturer of the vehicle, indicates or states that a specific safety type of procedure shall be recommended, they recommend you handling it this way, and the shop does not because it's just recommended, how or will the BAR issue a citation on the auto body shop?
So what I would say is that it depends on the recommendation we're talking about. So if we're talking about a repair procedure issue, like sectioning a frame rail, or how you put the spot welds a certain distance apart and using certain types, those would be issues in an inspection if we found we're not done in accordance with those, I would say OEM standards, but you're calling recommendations. Either way, I would say, yeah, we probably hold them to those recommendations. But without knowing the entire universe of OEM recommendations, there might be stuff out there that maybe we wouldn't. Like maybe they say you need to, I don't know, wash the tires or something after you fix the car. And so like, well, no, I don't think we're going to issue a citation because the OEM recommends you wash the wheels. So I guess it depends, and that's really, I guess, the answer I have for that. Now, I suspect where you're going to go is you're going to ask me about pre-scan and post-scan.
Yes.
And I don't really know that I have an answer for that one either. But I will say this, is that I would imagine if I was a consumer who got in an accident and I picked up my car from the body shop and the check engine light was on, I'd probably be upset.
Yeah, no, and I was going to ask you about the post and pre and pro scan calibrations, because this is an issue that the manufacturers have recommended that the shop follow, and according to 3365, the services shall be performed in accordance with the OEM service specifications. So auto body shops are naturally concerned. They're saying, listen, if we don't follow the recommendation, because it's a recommendation, will we have a citation up to potentially $5,000 fined on us? So that's a very important issue. And I know that I've been asked that question, and that's why I'm asking it here today in a public forum, because that's going to be an issue on 3365. So I just wanted to raise it at this point, have you consider it, and have your team consider the ramifications with respect to 3365. Okay, let me just 3366, the air conditioning trade standards. Let me throw this out. So I know there is a trade standard on 3366. There's 16 or 17 provisions in there that you have to follow. Most of them deal with the existing or the actual work. Okay, the work. In other words, you got to inspect coils or examine coils, check for leaks, that sort of thing, right? But also in that regulation in 3366, it also states that the invoice has to list the high-low systems that you're recording, on the final invoice. Okay.
Mm-hmm. And the center vent temperature. Yep.
Okay. So my question is, if a facility violates the section dealing with they failed to do the service work, examining the coils, I would assume you would be issuing a violation under 3366, right? I mean,
If we could prove through investigation that they failed to do one of those 16 items you referenced, yeah, they would get a citation.
Okay, but if they fail to list the high-low, on the final invoice, do you see that being a violation of 3366, or would that be a violation under an inaccurate invoice?
Well, I don't think it would be an inaccurate invoice. I guess what I'm wondering. I think it would be, if it's a violation of anything, it's 3366, and that's the trade standard. And so I would imagine it would be a violation of a trade standard.
Okay. I'm just throwing that out because I know that the section, it's that there's 17 areas within, or 16 or 17 areas under automotive air conditioning, and if a shop simply fails to list, they did the work,
Mm-hmm.
the high-low on the invoice, they're going to be cited for a trade standard violation versus an inaccurate invoice. And I think that's the reason I'm raising it, and I think it's important to consider is assuming AB 341 passes, they may be eligible for remedial training under an inaccurate invoice, but maybe not under trade standard. You see where I'm going with that?
Oh, okay. Fair enough.
Okay, I'm just raising that particular issue. Let me move on. On the next page, page 7. Maintenance of records. I know you've got it listed. You got a violation under BMP Code Section 9884.11 and then 3358, which those are broad sections. So I guess the intent is not to issue a citation under 9884.11, nor under 3358, but the new section 3358, whatever is 0.1 or 2.
D1.
Yes. Is that
That's
correct?
A good point.
So I guess what I'm saying is that under the maintenance of records on page 7, you guys are going to be deleting BMP Code Section 9884.11. You're not going to be issuing a citation under that. Is that correct?
Yeah, I think the only other BMP that was listed out had to do, I think, with ignition interlock, right? But I mean, short of that, you're right.
Okay, I just want to clarify that. Okay, we touched on. Let's go to page 9. And thanks for bearing with me here on this. This came up before, I can't remember if Johan mentioned it or someone mentioned the concern here on the inaccurate invoices. So this one is, when you say inaccurate, it's very, very broad. And I was just trying to come up with a potential solution because the way it reads now, it could literally mean if a shop doesn't dot their I and cross their T, you can issue a citation. That's the way I read it right now. It's very broad. I mean, it's very subjective, I should say. And I don't think that's necessarily what you guys are, or at least what you're trying to, to trying to deal with here. I think it's more than just dotting the I and crossing the T. If I'm not mistaken, that's what you. So I was trying to figure out a way to really. I mean, I think there's scenarios here where a shop may, for example, I know that there's a signature acknowledgement in invoices, right? There's a section where you have them acknowledge, there's a notice of acknowledgement for oral, for an oral approval of an increase of an original price, right? And
yeah, so they don't have to transition the additional authorization notations to the final invoice.
Correct. But as you know, there may be instances where, there wasn't no increase in price. It was just the estimated price and that was it. And of course, some of the shops are very cautious and they have you sign that, initial that. And technically, that's an inaccurate invoice, right? And in fact, some of your people may even say it's a misleading or false statement. Maybe.
Yeah, maybe. I would say, though, that I don't know that inaccurate. I don't know that it would be an inaccurate recording of the service work or service or repair work performed in the parts supplied.
Well, I guess my point is, I don't know. I guess simple, just mistakes are kind of the concern. You don't want to be issuing. I don't think that your intent is to issue or have authority to issue citations on simple mistakes. And I guess my fix would be, or at least a suggestion would be, to put some sort of adjective before inaccurate. Maybe, you know, it's got to be substantively inaccurate or something like that. I mean, I just think it needs to be modified because it's so broad right now. I'm raising the issue. I wanted you guys to at least consider it because I do think it's very broad.
And that's fine. I'm just trying to, the idea of calling it significant or substantive, that that in your mind takes it out of the idea of, well, so like, Johan's suggestion about the fact that it says remand instead of remanufactured, or R&R instead of remove and replace or remove and rebuild. Do you feel as though that corrects that issue?
Well, it goes in that direction because I think then if you say, you know, something like substantively, I don't know if that's the right term, but I'm just throwing that out. Then at least you're dealing with the situations where I think you're trying to get at, where someone may charge for a part and not put on, for example, but there's no intent to defraud anyone. They just simply made a mistake, right? They ordered the part, the tech failed to put it on, install the part, okay? And there was no intent. You can't prove fraud. You're not going after them for that, but you can issue a citation there. And I think that would be reasonable. And to issue a citation, that's it. Or the other scenario is where maybe the shop did perform a service but didn't charge for it and didn't list it on the invoice, right? So it can go that way too.
Mm-hmm.
And so, you know, I think those are the areas maybe you're looking at, as opposed to, again, going back to you didn't dot the I, you know, and cross the T. And so I think that's the concern, that this won't be abused out there in the field. And I just wanted to have you guys just digest that and think about that.
Okay.
Fair enough? Okay.
Mm-hmm.
And then, let's see, page 10. The negligence. I know that came up and someone, I don't know if it was Johan, whoever mentioned it. So I think the definition and negligence is overall is good. I think maybe it's the lawyer in me. When I read means a deviation from the ordinary standard of care, I think the intent is the ordinary standard of care for an automotive repair dealer versus just a reasonable person standard, right? You're going to compare shops with shops, not a shop with a reasonable person, a consumer out there. So I think it's something, this is more of a legal issue, but a deviation from the ordinary standard care or ordinary standard care of an ARD. I think that needs to be kind of cleaned up a little bit. Just a comment, and have your legal people take a look at it. But I think it needs to be tightened up a little bit.
Okay.
And let's see. Finally, on page 12, I know Dave mentioned this one, the suggestion. This one, I got to tell you, the drafting, it sort of it raised a red flag because I'm not familiar with any other regulation which says that somehow may be grounds for disciplinary action or issue a citation. I've never seen that before. And that sort of stuck out at me. I'm like, that doesn't, I don't know, something's not right about that. But there are two areas, and I agree. I think Anthony mentioned this about what a reasonable inspection is, open for reasonable inspection. That needs to be defined. And the other, I think it's very broad and it needs to be tightened up. And I agree with the day, have an amount of days. The other area where I think is very broad is requested by the Bureau as part of a consumer complaint investigation. As part of a consumer complaint investigation, that seems very broad to me. I think it needs to be tightened up because I think the intent, as you discussed earlier, you were focused really on specific consumer complaint records, right? That's what you're after. Yes. So when I see Bureau as part of a consumer complaint investigation, I think you can ask for 90 days or 3 years worth of records. I think it's very broad. I think it needs to be tightened up. That would be my suggestion there. I do like the idea of 10 business days. and I think some of the examples were mentioned about the warranty. I know that there are examples where a consumer may make a complaint to the BAR, and they may have brought their car in 4 or 5 times, or they may have a couple of cars they brought in, right? And it may take the facility, some time to gather all those records, especially if the customer is, a longtime customer, they've been bringing their car for the last, 4 or 5 years, and they got to go back, and check those records. So my suggestion on this is that somehow something to the effect that the records that relate to a specific consumer complaint need to be open for investigation within, or no later than, they got to be turned over, but no later than 10 business days. It's very specific. It covers, the scenarios where we mentioned that maybe, warranty issues. And I think it really tightens it up. And so if you're going to issue a citation, I think it's clear to the business, listen, you got to turn over those specific records, specific complaint records within a certain amount of time. And if you don't, you're going to get cited. I think that's fair and reasonable.
Did you and Dave talk about the 10 days?
Yes.
Or were you inspired by Dave?
It's all Dave. It's all
me.
Dave.
It's all me.
It's all Dave. We're on the same wavelength than that. But I think the 10 business days is, I don't know, anyone else can comment, but I think that's fair and reasonable. That's basically 2 weeks. Let's face it, right? That's basically.
It is essentially 2 weeks. The only thing I'm concerned about related to setting this date is shops that would otherwise comply within a shorter period of time, thinking about the time frames related to our complaint investigations. I don't know if I'm literally setting us up to always have to wait 10 days. I mean, probably not. I would say that the shops I would call and say, hey, I'm going to be there tomorrow. Can you get those records for me? Can you please have them available, make copies for me, and I'll get them and we'll deal with it all at one time. I'm sure even if we said you have up to 10 days or within 10 days, you have to produce those records, they probably would get them for me anyway. But yeah.
Yeah, no later.
I don't want to set it where now nobody gives them to us. It's 10 days, come and get them because I'm not giving to you before then.
I think you can come up with some language saying, hey, you got to turn them over, but no later than 10 days or something that's fair. I mean, I think most shops will turn over they'll want to get, the legitimate shops want to be able to resolve issues pretty quickly, right? I mean, and so I think you're going to get cooperation. Now, the people that are not going to cooperate with you, they're not going to even care about the 10 days, right? I mean, you're going to have to fight them tooth and nail. I don't know if it's going to be an issue, but I think we can work on the language. Again, that's just my thought and my suggestion. But overall, like I said, I think you guys, or at least your team, Matt, I mean, and I know you're working with the entire team within the Bureau, have done a really good job overall. And I think from the last bag of a workshop, I think they've really been improved. And again, we just got some tweaks here and there, and I appreciate all the work that all of you have done. I know this takes a lot of time and effort, so really appreciate all the work you've done. Thank you very much.
Thank you, Jack. I just got one quick follow-up because I moved on to one part but not the other part, and it had to do with you were raising an issue. So in my mind, the way that this is written, it's related to a specific consumer complaint record. But if you wanted to reword that in some way, what's your suggestion on how, if you feel like it doesn't say that, what do you think it should say so that it does say that?
Well, I think I would, again, this is not my exact language, but something to the effect that, records relating to a specific consumer complaint investigation or something, a specific consumer complaint, tighten that up. Because it just says consumer complaint investigation. I just think I need that adjective in there, just saying a specific consumer complaint. That's what I would add in there. And then I would just, tie it into the amount of days.
Okay, thank you.
It's just tweaking the language.
Read.
Thank you.
Thank you.
Thank you, Jack, for the comments. Appreciate it very much. Let's go to the next hand. I see Anthony's still raised, but I'll get to everybody else at least one time before. Oh, he dropped it. Bud Rice.
Yeah. Hi. Good afternoon. I know somebody said this in passing, but I really want to make sure that the notification goes to the management team of the organization. I mean, I've got multiple shops, and it happened to me once that I got a letter from BAR and the guys were busy that day, and they grabbed the envelope and put it next to the cash register, and then they were just doing work. And then I came in there probably later that afternoon, and then the next morning, and then that afternoon, and then the next day is when they finally said, "Oh, Bud, we got a letter here." And I go, "Well, when did that come in?" And they go, "Well, it's like 2 days ago." And I went, "No, I need to know that, as soon as possible." So they weren't trying to hide it; they just put it off to the side. But I could very well have not known that for 5 days or something, for all I know. So the notification's got to go to the owners of the location or the management team of the organization. So
Yeah, that makes sense.
thank you.
And while we're here, Bill's texting me, and he suggested we just go with the per the government code. I don't want to misrepresent. Hold on, I'll read it. Unless Bill, you want to chime in because I know you're on here. But I think service should be executed pursuant to the government code.
Thanks. You could have honked the horn on that bus before throwing me.
Honk the horn? I thought I did. That was me
Let
honking. I was telling you, wave.
Heads up. No, on this service, yeah, there's a provision in the government code that specifies what proper service is. And we follow that on our smog check, on our health and safety citations. And I'm assuming we would follow it with these citations as well. And as to mailing it to a specific person, we're going to mail it to the attention of the owner of record as listed on BAR's licensing in CAS on BAR's database, who the owner is. And we're going to mail it to the business address of record, which is what's published on the website. And we're going to mail it to a secondary mailing address if the owner has specified such an address. And we would mail it regular mail and certified mail, which is what we do with citations. So there, in most of our smog check citations, if there's 2 separate addresses, we're sending out 4 copies. And we have to do that. It's due diligence to make sure it gets to the owner of record. If after that, the owner doesn't get it, anyway, we're gonna serve it that way. Personally serving them, my thought is, and unless I'm missing something here, and I haven't been in on any of the meetings for this process, most of our smog check citations, and I'll just speak to that process since Matt gave me the opportunity to unmute myself. He may regret that afterwards. Our smog check citations are generated through a report from a field investigator who sends it up to headquarters, where it's reviewed and evaluated to determine if a citation is appropriate. And those citations are issued on behalf of the chief. And I would think we would do the same thing with these citations, these ARD citations. So the subjectiveness of it is eliminated through that process. And that's all. I would want to reinsure everybody on this call that process would be part of, would take place here as well. And so that these citations are issued consistently and objectively statewide.
Sounds good.
All right. Thank you very much, Bill, for chiming in there. Makes a lot of sense to me. Follow the template we are using for the smog check violations to issue citations and the service process there. Let's see. Anybody else? Not of any of the advisory group members. Let's see if we want to open it up for some additional participants who are here on the meeting.
I think Nikki literally has her hand up.
Is she really?
Literally putting her hand up.
Oh, she's not doing the virtual hand. I don't
Not the
recognize.
virtual hand.
Yeah, no, virtual hand only. No, I'm kidding. Go ahead, Nikki.
I'm sorry, I thought I did. I apologize.
I may have missed it.
Or maybe.
This may be a really stupid question, but are you going to have a list of what each violation costs? I mean, I don't know. I don't quite understand or follow how that is. And if you have one complaint, how do you go from $0 or $100 all the way up to $5,000? I just don't understand. And if you have one repair order and you've written something wrong, maybe in 2 or 3 places, is that going to be a different cost on each one?
Okay.
I mean,
So-
may sound stupid, but I really don't understand.
Well, I'll say is that, I mean, if you're looking at what I pulled up here, 3394.51,
Right.
these are the factors that will be considered in determining the citation amount. If you're asking me if on one invoice you inaccurately recorded the service work performed and inaccurately recorded the parts, so, and we weren't able to prove it was an intentional act, it was rather an invoicing error that caused an inaccurate invoice. Well, in that situation, there's one invoice. I would imagine there's only going to be one citation, one violation.
But it could be more, right?
I guess it would depend.
Depending on who you're talking to.
I mean, if it's one repair and they're
Okay.
one repair, so you didn't put the rebuilt alternator on, you just left it off the car. And so I'm trying to think, like, we have an issue with related to not installing the alternator, and we have an issue to the parts description because it wasn't on the car. No, I don't think that's two separate violations. I think it's just one issue. It's one event.
Okay. Is that
But we'll see.
Makes sense. Yep.
okay? Is that going to be delineated anywhere?
I'm sorry, what's that?
Is that going to be delineated anywhere? One repair order is one repair order?
Well, okay, so all I'll say is that okay, so will it be
Is one
delineated
event?
anywhere? No, I don't know that it would. I mean, like, we're not going to have, I can't imagine a situation where we have amounts. I mean, the regulations kind of say how the fine amounts are determined based on those 4 factors that are in this section. So we start with there. Can I have a consumer complaint in which multiple violations that meet the citation criteria occur? Absolutely, you could. And you could have a citation that would have multiple violations for whatever reason. That could go through, maybe you're an auto body shop that didn't follow trade standards and you don't have the required equipment. Like, I don't know. So if you're looking at, now I have 2 separate citable offenses that occurred. Now I'm issuing a citation based on 2 different citable amounts. That's going to be more than if it was just one, but I know that I can't exceed $5,000 because it's in the regulation.
Okay.
It doesn't seem to me that it would be, it wouldn't be multiple citations being issued, but it might affect the citation amount based on the gravity of the violation, item number 1. In that case, you have multiple violations. It wasn't just a simple paperwork error or something along the lines of an inaccurate invoice. You have multiple violations suggesting gravity, tipping more on that side of the scale.
Okay.
So I hope that got there. I feel like you're asking a question I don't really have a really great answer for other than the scenario.
But it is one event, and we wouldn't be issuing multiple citations for it. I don't envision that.
Okay. Thank you.
Let's see. There's your hand. I see it now. Okay. All right. Let's see. Anybody else? No, I don't see anyone else. Let's always.
Patrick, can you?
Yeah.
It's Lou.
Mm-hmm.
My hand's been raised.
I don't know why I don't see it, but go ahead.
You don't see it on your screen?
No, I don't, but
Okay.
you're up. Go ahead. Thanks for jumping in.
You betcha. Thank you, everybody. First of all, on the definition of negligence, so this is your slide, where are you? Slide 10, I think. I think we need to harmonize the statute. I don't think it's in harmony right now. So it starts off by saying an automotive repair dealer shall not commit negligence in the maintenance of and or repairs to a motor vehicle. So we have 2 different things going on here. We have maintenance services and we have repair services. And I think we all recognize in the industry, we look at those 2 things separately. So I think to use both a conjunctive and disjunctive term and or is appropriate because you can have a customer who comes in for maintenance and not only is maintenance performed, but some repairs or in the inspection some repairs are needed, and so you have both maintenance and repair services going on with the same customer, but the same visit to the shop. So I think that's appropriate. Now go to your next section of the code. Negligence means deviation from an ordinary standard of care that could foreseeably result in injury or harm to a consumer, personal property, or the public during or as a result of repairing a motor vehicle. I think you need to put before repairing a motor vehicle, maintaining or repairing a motor vehicle. That would harmonize it. Section B would then be in harmony with Section A.
Good point. And I think Lucy's going to appreciate that you liked how A was written.
Pardon me?
Our analysts will really like I think that you liked how A was written.
Well, it's fine. I'm not gonna quarrel. I think it reads the way it needs to read. But when you get to B, again, if you harmonize that with A, now it's consistent. But the next comments are going to fall under the heading, the devil's in the detail. So you start with the negligence definition, which is the generic legal definition of negligence that we learn in law school. Okay. It's a deviation from an ordinary standard of care. Jack has suggested that without any qualification, we're looking to a reasonable person standard. I don't think you want a reasonable person standard when we're talking about the repairing and or maintaining of automotive vehicles in California. I think you need to put something in that section, an ordinary standard of care of an automotive repair dealer, or something to the effect. You have to tie ordinary standard of care to the maintenance and repair of automobiles, because that statement standing alone, it's not going to mean much unless we relate it. It's in a vacuum, is what I'm suggesting. It needs context, and Jack was suggesting context, and I think Jack's right in that regard. Here's the devil in the details. Ordinary standard of care. We want our automotive repair shops, our owners, our technicians, to know what conduct is acceptable and what conduct is not acceptable in terms of negligence when we talk about the maintenance and repair of automobiles in California. When you talk about an ordinary standard of care, are we talking about conduct? How do we determine what the standard of care is in any given circumstance? What are we looking at by way of criteria? Do we look at what the industry typically does in a repair and or maintenance circumstance? I think that's right. I think we do. But what does the industry do? Does the industry follow, for example, if you have a shop that follows MAP guidelines? All right. Does that, if a shop is following Motorist Assistance Program guidelines in the repair and or maintenance of a vehicle, has the shop followed the ordinary standard of care? What if BAR doesn't agree with all of the MAP guidelines? The shop follows the MAP guidelines and still the BAR issues a citation. How does the shop know? How does the technician know? How does the owner know what is acceptable conduct and what's not acceptable conduct? It would be like driving down the street and you're going through a area of town where you're not sure what the speed limit is, and you pass a sign that says speed limit 30, 35, and 40, and you decide to go 35, and yet you get cited for speeding because you should have gone 30. All I'm suggesting is when you take ordinary standard of care, you've got to put it in the context of automotive repair, maintenance, and or services, because that's how you've defined negligence. And you've got to think about all the different criteria that goes into establishing the standard of care. Who establishes the standard of care? It's not BAR. BAR doesn't establish the standard of care. It's the industry. Where does the industry look to know what is the standard of care? And if the industry looks to guidelines that the BAR doesn't agree with, how do we know as industry what's acceptable, what's negligent, and what's not negligent in any given circumstance? Again, the devil's in the detail. I think this needs closer. I think Jack was onto something in terms of talking about putting ordinary standard of care within, first of all, within the context of providing automotive repair, maintenance, and repair services. I think that needs to be done. And secondly, we need to tell industry what criteria are we looking at? Where do we find ordinary standard of care? What's the criteria that establishes, or where do we look for ordinary standard of care? All right, so that's my comments on that particular section. Let's go to 3356.1, inaccurate invoices. So is Bill still on? Yeah, I see Bill. So Bill, this is actually for you or Matt. It's a question. 3356.1 says an automotive repair dealer shall not create an invoice that is inaccurate in the recording of service and repair work performed and or parts installed. So to Bill and Matt, my question would be, how is this different than B&P Code section 9884.7A1, untrue and misleading statements?
I
ahead, Bill.
have no answer. I have no answer to that question. So I'm gonna fall back on the disclaimer that I was unfortunately not able to participate in any of these discussions and figure out how we got there.
Yeah, but Bill, your insight is critical because you deal with these issues every day, and when you and I talk, we know. I mean, this is. Is it the same? Is it basically the same thing?
And I think what the intent here is, and certainly we need to, the intent is to create a basis where, and this is something that Jack was talking about, where we want to have the ability to issue a citation in a circumstance where it was clear that the ARD there's no intent of wrongdoing here. And so to your question is correct. Is it a false and misleading document? Yes. Are we going to issue citations for deliberate false and misleading documents? Probably not. We're probably going to be looking more to file an accusation because that's the appropriate discipline. So it's a matter of getting the verbiage in such a way as to separate the intent and wrongdoing that warrants a disciplinary action as opposed to something that a corrective notice through a citation needs to be issued. And so, yes, we need to.
All right, so let's make this real though. You have an ARD in an undercover run who charged for a service that wasn't performed and charged for a part that wasn't installed, and you've now charged the ARD, besides fraud, with untrue and misleading statements because the invoice is wrong.
Right.
You got that situation. You have that in mind, okay?
And in my mind, that's going to be an accusation if it's an undercover run and we can clearly prove that. You know, I know Jack raised the point of, well, the technician forgot to put the part on, and that's probably something an ALJ is going to have to bear out. Okay,
but juxtapose that situation as to the ARD forgot to put the mileage on the invoice, put the wrong mileage down on the invoice. Wrote remand instead of remanufactured, used R&R abbreviations. Juxtapose that situation to the first situation I gave you. How do you view that? In other words, the situation where the invoice is inaccurate because somebody didn't record something, didn't record the mileage on the odometer correctly.
And I think that's the intent here. And your comments, what they're telling us is we need to go back to the drawing board and maybe delve a little deeper into this verbiage to make sure we have it right so that we can clearly delineate between those two examples you've raised.
Well-
First example, deliberately not changing a part is going to be a case. Second example, you know, an error in the odometer reading or something like that is probably going to be under this regulatory package. And so
What
it's
I'm
just a
saying is-
matter of,
And Bill, you did a great job because you actually weren't involved in any of the conversations, and you kind of you got to where we were at. And
right.
Lou, we're not going to issue a citation because they didn't record the invoice. Or I'm sorry, on the invoice they didn't record the odometer reading or had a number off. It's if it's more significant. If it's inaccurate, it's because they didn't record the service or repair work performed or the parts supplied. They were inaccurate in the reporting of that work.
Well, why don't you give me a circumstance, give me a real life circumstance where you see issuing a citation for an inaccurate invoice. What would that invoice look like that got a citation?
It probably would record a TPMS sensor that we
Okay.
found out wasn't in the tire. But
Okay.
upon looking at additional invoices, we couldn't find any other cars that didn't get TPMS sensors. Looks like it's not an intentional act. Maybe it was just an oversight. They're going to they'll get a citation in that situation. If I pulled those records and I found a lot of cars that didn't get TPMS sensors, well, now we're looking at a different situation. We'd be writing a case as opposed to issuing a citation.
Well, when I use the example of an inaccurate odometer reading or R&R or abbreviation instead of writing out the actual service, that is part of the recording of service and repair work performed. Those are all part of that same thing. So when we get to my comments on the proposed text, which is going to be coming up here in just a second, you'll see where this comes in, because what you're setting up here is a spectrum of wrongdoing. Where in the spectrum do we find wrongdoing in terms of we find an invoice that's inaccurate, that's going to get a citation, versus an invoice that's going to not get the benefit of a citation, that's going to be part of a larger case, which would be the filing of an accusation. All right.
And that is whether we can, through investigation, determine if this is an intentional act or not.
Yeah, well, again, and the intent thing, what Johan was talking about, that's another issue that you need to think about with more clarity. So if you go to the inaccurate, the adjective inaccurate, as again Jack was struggling with that. The reason I asked if this code section or the proposed reg 3356.1 is basically the same as 9884.7A1, if the answer was yes, couldn't you just simply say, instead of inaccurate, substitute the words untrue or misleading in the recording of service and repair work performed and our parts supplied? Wouldn't that take inaccurate out of the picture? And now we know it has to be either untrue or misleading. And that's assuming that you want to keep 3356.1 in harmony with 9884.7A1 of the B&P code.
I think we're actually trying to keep it in harmony with 9884.8.
Or 8, yeah, either way.
I would think that based upon all the comments we're getting on this proposed section, that we need to go back to the drawing board internally and have some discussions as to where this is a difficult area, to where, there are other areas where a citation is certainly warranted to an ARD. There's the failure to provide records and things like that. There's also, I was searching for grounds for discipline per Jack's comment earlier, and I found 139 or something like that in B&P, failure to provide a change of address. We get that all the time. That might be a good thing to put in this regulatory package and pull out invoices entirely, because there are some, like Matt said, and if they record the odometer reading inaccurately, we're probably not even going to issue a citation there. But if they fail to replace a part they charge a consumer for, we're not going to issue a citation there either. So is there really a world in which an inaccurate invoice warrants a citation, or are most of them going to be either in the category of an office conference and a conversation or an accusation? Is there a middle ground there? And I'm not sure there really is. And that seems like a conversation we got to have back at bar.
All right, so let's segue from your last comments. Let's segue into the next thing I'm going to raise for you. And Matt, I needed to preface by what I said, starting my comments. I think you and your staff did a wonderful job of listening to what was said in April and really thinking about the comments and going back and reworking what we have today. It gives me a lot of confidence in you and your staff to see how hard you've worked and how closely you listen to the comments, because I can see where you made your changes, and most of them were very, very good changes. So kudos to you guys. Let's go to slide 5 if we can. So when you see that the different factors that go into the amount of the fine, first of all, gravity of the violation, that assumes, again, following up what we just talked about, that's a range, that's the spectrum. Gravity implies a high and a low. So are we talking about, is it a qualitative determination? For example, in any given circumstance, there was 6, 8, 10 different violations? Or are we talking about more substantive type of violations, not just numerical, but the gravity being the substantive violation itself? What does gravity of violation mean?
Seriousness of the violation.
Okay, but how do we determine? Everything is premised. My comments are premised on as a licensee, our clients are entitled to know what is expected of them in any given circumstance if they're facing a citation, what they're supposed to do, what they can do, what they cannot do. They have to know how to conform their conduct to these code sections. So when you just say seriousness, that doesn't help at all. What are we talking about? Numerical violations, qualitative violations, substantive violations? What goes into the gravity? Give us some examples. What would be a range of gravity here?
It would have to do with this. It would have to do with the findings of the investigation.
That's non-responsive though. I get that. But what give me some real world examples of good and bad, high, what would be a less severe versus a more severe violation in terms of gravity?
Why don't I go to the chart and we can take a look. So let's just say we had a violation, or we want to issue a citation because an air conditioning shop failed to record the high and low side pressures on their invoice. Imagine that wouldn't have a lot of gravity if that was the only issue. I imagine that if we were looking at a situation where a body shop failed to, I don't know, glued the roof on a car, maybe that would be a case anyway. I'm thinking that if a body shop decided to attach panels with sheet metal screws instead of welds, I guess if we were going to issue a citation as opposed to doing a case, that would probably be on the higher end.
All right, so you suggested seriousness. I'm more comfortable with the word seriousness than I am gravity. I really am. So I'm gonna keep moving, and I apologize, but I've got to be someplace in just a little while, and I need to get through these comments with you guys. Let me ask you overall, Bill and Matt, are we still going to be doing office conferences, assuming this citation program comes into law? Is BAR still going to be conducting informal office conferences with licensees?
Of course we would.
Okay, good. And, of all the many office conferences I've been involved in over the years, some go well, some don't go well. There's a variety of factors, but the office conferences that do go well, one of the things that I find that's consistent in those situations where we have good office conferences between BAR and the licensee is good communication. We have we have the, the bar field reps being respectful of the licensee and listening and asking good questions, and the licensee being respectful of the bar reps and responding in an open way, and they're really communicating back and forth. Could the bar issue a citation during an informal office conference?
You see, I can't imagine that would, look, I don't want to say never, but I don't think that would be the practice, because the citation would be as a result of a specific event in an office conference is to discuss a pattern of conduct.
If the reason for the office conference, after the office conference, if the bar feels that it learned things that it didn't necessarily know before going to the office conference and now feels the need to issue a citation, the bar could do that, couldn't it?
Well, I guess hypothetically, but honestly, it would probably work exactly the opposite. We would have issued a citation, and then at some point, in a result of a pattern of conduct, we bring you in for an office conference, a citation would have already been issued.
Well, that's come on. That's not my experience. No.
Lou, I would think that it's one or the other. And again, like I mentioned earlier with our smog check citations, I think the vision here, and I think this is the chief's vision too, is that the report, if the field office believes an event warrants a ARD citation, they're going to have to send an investigative report to headquarters to be reviewed for consistency, and then that would be issued. And the ability to come out of an office conference frustrated and say, all right, well, now we need to issue them a citation, they would still need to support that with further evidence than what warranted the office conference. So I don't foresee, and there are people above my pay grade, and that's a phrase I like to use when you and I are talking, that could overrule me, but I don't foresee this being a subjective. It needs to be controlled and administered from headquarters so that there's consistency, and I just don't think there's going to be those circumstances arising. I don't see that happening.
Okay,
and
so
plus, it would be really inconsistent with the goals of the Bureau to have an office conference and then take things out of the office conference and issue a citation based upon those. We wouldn't have our registrants participating in an office conference if we developed that as a pattern. I don't see
Bill,
that as it happening.
Bill, you hit the nail on the head. That's exactly the issue. If you're going to If the bar has the ability to cite licensees based on what they learn in an informal office conference or what transpires during an informal office conference, you've stifled the dialogue. If office conferences are successful because of good dialogue back and forth between bar and the licensee, which I found, we've got to be careful that the licensee feels free to talk to the bar about whatever the reason for the office conference without the sword hanging over the licensee's head that here comes the citation, because you're not going to have open dialogue. And so it's going to be that the citation process could be counterproductive to the whole informal office conference, which I think we can all agree has been a successful program at bar.
Maybe there's a way to put that sort of safeguard in there in the language. I'm not sure it's possible, but we'll take a look at something like that, Lou.
Okay, all right, and that Patrick, with that having been said, I think everybody else has covered either comments that I had or I think of what I've said what I need to say in terms of what I'm seeing here in front of me. Thank you for the opportunity.
Some really good comments. Thank you so much, Lou. I'm sorry I still don't see your hand raised. I'm not sure what happened with that feature on our.
No respect, but I'm used to no respect. Don't worry about it.
Rodney Dangerfield.
Always feel free to jump in, and I appreciate you doing so. Thank you. What else? Anybody else? Okay. We've gone past our hour and a half time slotted. We did say until the close of business. Are there any comments from other attendees that did not get addressed? I don't want to necessarily have a repeat of any of the issues that have been discussed already. Kind of looking for new information or new comments. there a way to check on that, moderator?
Yeah, let me go ahead and open up the Q&A feature. Anyone else who is on the meeting right now, if you'd like to make a comment, please click that Q&A icon down at the bottom right-hand corner of your WebEx screen. Currently sharing instructions on the screen for your reference. And I'll go ahead and pause a moment to allow people time to access that Q&A panel and submit their requests.
Again, we're looking for new information, new comments. Okay.
All right, looks like we do have a couple requests for comments, so we'll go in the order that they are received. First individual is Jonathan Summers.
Okay.
And Jonathan, I will be requesting to unmute your microphone. Please click OK when WebEx prompts you to unmute.
For allowing me to make a quick comment. Going to 3362.1, slide 6, the engine change. There's two definitions according to the bar. 3262.1 refers to the degradation of emission controls during an engine change, replacement, or rebuild. Whereas in Appendix A in the smog check manual, engine change is specific to the installation of an engine that is different from the one that was not originally installed in the vehicle and does not qualify as a replacement. So the terminology of engine change under the proposed text it has two specific definitions. I guess it will work if it's the engine change, replacement, or rebuild. But 3362 refers to the degradation of emission control devices during the process of all three.
Okay. I apologize. Do you have a question, or can I answer a question?
My apology. Did you hear my question?
Well, I heard your statement. The question was, does it apply to all?
That's all it was. It was just a statement.
Okay.
It wasn't a question. I just noticed the word engine change, and the specific verbiage of engine change is installation of an engine that is different from the originally installed in the vehicle.
Yeah, so the trade standard 3362.1 engine changes, that's within Article 8, or accepted trade standards for automotive repair dealers. That's what we mean. And that's the title of the section. That's the reason why it's there, as opposed to me actually loading the whole text in for the the code section itself.
Now, what about the definition that's in the smog check manual, which is quite different?
Yeah, but that's not going to fall within Automotive Repair Act violations. That would be within smog check.
Okay. Thank you.
Okay. Our next comment, moderator.
Yes, so our next individual's requested public comment is individual identified as Annie Paparinian. Annie, I'll be unmuting or requesting to unmute your microphone. Please click OK when WebEx prompts you to unmute.
Hear me?
Could you try speaking again? You were a little quiet.
Sure. Can you hear me?
You're a little quiet. Is it possible that you can get closer to your microphone or adjust your input setting?
Yes. How about now?
A little better.
A little better.
Okay. I apologize for that. I'm using the computer's microphone that's built in. I wanted to know where we can get a copy of all this proposed regulations, and is there still a period of time that we can make comments, when we could expect revision and then adoption and enforcement?
So we're
We'll take care of that.
Oh, go ahead. Go ahead.
I was just going to say the regulations, the draft regulations are up on the website where the meeting notice is, all the materials, including the presentation, the draft regulations are there and available for the public. I've been out there since roughly 10 days or more from today's meeting date. And we'll be going back to the drawing board with some of these provisions and looking to redraft them, and then coming back probably for another workshop, if not in October, sometime shortly thereafter. And then there'll eventually, when they get filed as regulations, there'll be a more formal public comment process once the regulations are in their final form, if you will. So a lot of work still remains to be done on them.
Okay. And if we can we just simply send comments to you all ahead of time, or is this something much more structured where you want these comments to be done in this type of a format when there's WebEx meetings?
No, you can send us comments. I think Matt had his his contact information, excuse me.
I did, but I'm not in control of the presentation anymore. Otherwise, I was trying to flip to that slide.
Oh, okay. It's on the last slide. The presentation's up on our website, so if we can't get to it right here, you can find it up on the website.
I appreciate it.
Yeah. Yeah.
Thank you.
Thank you very much. Any other comments?
This is the moderator, and it appears there are no further requests for comment. Would you like me to close that Q&A feature?
Yes, thank you.
All right.
And I see Lou's hand now up. Is this a holdover from the original comments where I didn't see your hand raised? It's interesting.
It should be, I thought I took it down. Is it still up?
Yeah.
How about that?
Okay, there you go.
Sorry.
I sometimes do that too. I think I'm raising it and I'm lowering the hand, and then I think I'm lowering it and I'm actually raising it. So I don't know.
Sorry, Pat.
No worries. All righty. All right. So as I said to Miss Papirian's comments, we're going to go back to the drawing board, if that's the right phrasing here. But we are going to look at some drafting changes to some of the provisions, and we'll look to have another workshop. I sometimes hope we can get more closely to the final drafting stage, to the point where we don't have to have another workshop, because it just seems like sometimes it can be an endless process, and there will always be a formal comment process when we officially file those regulations to the Office of Administrative Law. But I think in this case it really warrants it to have another workshop, because there are some significant changes that sound like they may be forthcoming as a result of today's comments. So we're getting closer. We're not there yet, though. Is there a comment there? It sounded like someone wanted to interject with something. No? Okay, so I think we are ready to adjourn. I want to thank all of thank first of all Matthew Gibson for the excellent presentation and all the work that he's been doing. Greg Pearson, who chairs the internal work group that initially started on this proposal, and then of course all of our bar advisory group members who are stuck around following the meeting earlier today, but stuck around for the workshop and provided some excellent comments to today's presentation, and then some of the public members, as public participants who chimed in as well and attended this meeting. Thank you also to our moderator, Sarah Arani, and her team over at the Department of Consumer Affairs. Cesar, I see you on here as well for the webcasting work that you'll do or are doing. Well, as I said at the outset of the meeting, we'll have this webcast recording up on our website hopefully next week, so you can get all of this and review it if you'd like to. If there was something you missed, it'll be recorded and can listen to it shortly sometime next week. So let's adjourn. We'll hope to see all of you at our next workshop. Again, if we can get things turned around quickly, we'll hope to do something in October following our next bar advisory group meeting, which is scheduled for October 21st of this year. So unless there is any other comments or questions, I'll adjourn the meeting. Thank you. Have a good rest of the week, everyone. Look forward to seeing you in October.
Thank you, Pat.
Thank you, man. Thanks, everybody.
Thank you.